Having discussed war powers, let's now talk about the related concept of emergency powers. Emergencies present a deep historical problem for the concept of the rule of law. It's easy to see why certain civil liberties or private rights might have to be curtailed or impinged under emergency circumstances. Ordinarily, citizens may be free to move about the city as they please, to conduct business or enjoy leisure activities at any hour of the day or night, and so on. If the city is devastated by a natural disaster or is threatened by an invading armed force, these freedoms might be temporarily restricted until a basic level of safety, order, and security is restored. It's also easy to see how this kind of suspension of the ordinary rule of law in favor of emergency rules can be abused. Perhaps the most famous example in modern history is the Reichstag fire decree, after a probably orchestrated fire in the German government building, which allowed Adolf Hitler to suspend civil liberties under the Weimar Constitution, providing the sham legal justification for the Holocaust. Calibrating the need for occasional emergency authorities with the goal of a just, stable rule of law is one important function of any constitutional instrument. The U.S. Constitution includes a number of emergency provisions. Article 1, Section 9, Clause 2 states that the privilege of the writ of habeas corpus shall not be suspended unless, when in cases of rebellion or invasion, the public safety may require it. Habeas corpus literally means having the body. It is a form of court order that requires the government to produce a person in detention for a court hearing, showing why the person should be so held, or else release the person. You may wonder why this kind of court order is so important that it found its way into the Constitution. The reason is that it's easy for authorities to charge a person with some kind of infraction and lock that person up. Once a person is locked up, it's usually physically difficult, if not impossible, to escape. If there's no procedure such as habeas corpus, the government could keep the person locked up indefinitely without any prospect of a trial to determine his or her actual guilt or innocence. Indeed, this is a popular tactic of tyrants large and small. Drum up false charges against a political enemy or other undesirable, lock the person up, and cause them to disappear in a system that never provides a meaningful opportunity for a public hearing. Notice, however, that as important as this writ was to the founders, they provided that it can be suspended when in cases of rebellion or invasion, the public safety may require it. This is why this provision is known as the suspension clause. Some of the provisions we discussed under the rubric of war powers can also be seen as emergency powers. And indeed, wars, invasions, and rebellions are typical kinds of emergency circumstances. This includes the provisions for calling forth and governing the militias in Article 1, Clause 8, Section 15, and Article 2, Section 2, Clause 1. In addition, Article 1, Section 10, which is a federalism provision that limits state powers over foreign and military affairs and other matters, includes an exception in Clause 3. No state shall, without the consent of Congress, lay any duty of tonnage, keep troops or ships of war in time of peace, enter into any agreement or compact with another state or with a foreign power, or engage in war unless actually invaded or in such imminent danger as will not admit of delay. Article 4, Section 4, a complementary federalism provision, states that the United States shall guarantee to every state in this union a republican form of government and shall protect each of them against invasion, and on application of the legislature or of the executive when the legislature cannot be convened against domestic violence. Notice here that it is in cases of invasion or domestic violence that the federal government is required to protect the states. The Third Amendment, part of the Bill of Rights, relates to a typical emergency war power that was particularly important to the founders, the quartering of troops on private property. Among the significant complaints in the Declaration of Independence were the complaints that King George III has kept among us in times of peace standing armies without the consent of our legislatures, has affected to render the military independent and superior to the civil power, and was quartering large bodies of armed troops among us. The Third Amendment limits but does not completely forbid this practice of quartering. It states that no soldier shall in time of peace be quartered in any house without the consent of the owner, nor in time of war, but in a manner to be prescribed by law, suggesting that Congress, but not the executive, can specify the circumstances in wartime when private quartering might be lawful. Finally, the Fifth Amendment provides that capital and other serious crimes require the presentment or indictment of a grand jury, except in cases arising in the land or naval forces or in the militia, when in actual service in time of war or public danger. Like the writ of habeas corpus, a grand jury is a hedge against abuses of prosecutorial discretion. It requires a prosecuting authority to convince a citizen jury that there is probable cause to believe the accused has committed a crime. Notice that a grand jury does not determine guilt or innocence, and that probable cause is a far lower standard than the beyond a reasonable doubt standard usually needed for a conviction. But the grand jury does at least require the prosecuting authority to present some evidence relating to something the law defines as a crime. Concerning emergencies, notice that the Fifth Amendment does not require a grand jury for cases in military courts when in actual service in time of war or public danger. As with constitutional war powers and the War Powers Resolution, there's a statutory overlay to the basic constitutional provisions regarding emergency powers. The Posse Comitatus Act, some version of which has been enforced since 1878, states that whoever, except in cases and under circumstances expressly authorized by the Constitution or Act of Congress, willfully uses any part of the Army or the Air Force as a posse comitatus or otherwise to execute the laws, shall be fined under this title or imprisoned not more than 2 years or both. This means that active duty Army and Air Force troops cannot be used for domestic law enforcement purposes unless authorized by the Constitution or Congress. A Department of Defense rule makes this restriction equally applicable to the Navy and the Marine Corps. It does not, however, apply to the Coast Guard. It also does not apply to National Guard units under the command of a state's governor, in which case they are considered part of the state militia. But it does apply to National Guard units called into federal service by the President. There are numerous statutory exceptions to the Posse Comitatus Act. The two most widely used exceptions are the Insurrection Act and the Robert T. Stafford Disaster Relief and Emergency Assistance Act of 1974. Some version of the Insurrection Act has been enforced since 1792, and it has been in effect essentially in its current form since 1807. It allows the President to deploy military forces to counter insurrections, domestic violence, and unlawful conspiracies if the constituted authorities of a state are unable, fail, or refuse to protect their citizens' rights, or if the unlawful action opposes or obstructs the execution of federal laws, or impedes the course of justice under those laws. The Insurrection Act was invoked, for example, by George Washington during the 1795 Whiskey Rebellion, by Dwight Eisenhower during the standoff over desegregation in Little Rock, Arkansas in 1957, and by President George W. Bush during the 1992 Los Angeles riots and after Hurricane Katrina. The Stafford Act allows the President to provide federal assistance, including military forces, if the President declares a state of emergency. The Stafford Act defines circumstances under which a state of emergency can be declared to include events such as natural disasters where federal assistance is required to save lives and to protect property and public health and safety, or to lessen or avert the threat of a catastrophe in any part of the United States. The Stafford Act is the statute that authorized the activities of the Federal Emergency Management Agency, FEMA, and is routinely invoked after major hurricanes and the like. A key feature of these statutes is that they include reporting requirements and time limitations that are supposed to ensure that the President cannot maintain federal control over the states through the fiction of a perpetual state of insurrection or emergency. In addition to the Insurrection Act and the Stafford Act, there are at least 20 other statutory exceptions to the Posse Comitatus Act. These include, for example, Section 1416A of the National Defense Authorization Act for fiscal year 1997, which concerns emergency situations involving chemical or biological weapons of mass destruction. A statute that authorizes the Secretary of the Navy to enact a federal quarantine and isolation of U.S. ports in the event of an infectious disease outbreak. And a statute that allows the Department of Defense to become involved in protecting against criminal transactions involving nuclear materials. I don't expect you to know any of the details of these statutes, other than what is discussed in this video or in the readings. The primary takeaway for our purposes is that the constitutional framework concerning executive war and emergency powers is reinforced by a statutory scaffold. That in some cases, particularly the case of the War Powers Resolution, it's unclear whether the statutory scaffold is constitutionally sound, and that the entire structure is relatively fragile and relies significantly on the moral commitment of the executive branch, including not least of the military, to operate under the rule of law, particularly when the rule of law is under strain because natural or man-made events break down regular order. This is the end of the lectures for this unit.